Hello and welcome back to the another episode of the Hindu News Analysis. Well, the date is 12th August 2025 and in this video we are going to discuss some important articles which are very much relevant for your preparation. So, without any delay, let us start our discussion by looking at the article which we had brought here. The article, as you can see, is about the gender justice and the recent court ruling. So, what is the story here? In this article, we are going to look at few important facts, few important points on which we will do our analysis, which could be very much relevant for your preparation. First, we'll look at the story of the article, well, what it is about, what is the case study which has been done under this article, as the case is about the Shivangi Bansal versus the Sai Bansal. Shivangi Bansal versus Sahib Bansal. So this is the case study, and what this article is about, it is about basically it would revolve around the domestic abuse which the woman faces through husband, maybe through the relatives and all that. And then we will see which act or which article deals with this, which act or which section of the IPC used to deal with it, and when the IPC was replaced by BNS, and then how it has been transferred to the BNS. So under this, it is the section 498, section 498A of IPC, which is now section 85 of BNS. So these are the few important facts which we have to look into, and then we will see what is the judgment here. What is the judgment here? Well, there is a case, there was an allegation from Miss Bansal against Mr. Bansal about the domestic abuse, and that's very much relevant when we are discussing this article, why it is there. And with respect to the domestic abuse, there are various laws which in our country which deal with it, which protects this, which protect women in our country. And it is not new. It is not new that there is domestic abuse in our country. It is not something which we are not aware of. It is very much evident from, unfortunately, it is very much deep rooted in our society. The women, they are not treated well. We hear often, cases against women where they are highly abused, maybe their husbands, maybe their relatives, maybe there would be sometimes at some places there they can go so far as the honor killing. And it is very much, very much in our society, unfortunately. So with respect to this, what is the section, what does the Indian Constitution say, or what are the laws which protect a woman against this abuse? So with respect to this, there is section 498A which used to deal with it, and it got transferred to the IPC under section 85 of the IPC. So what was the story here? That this case was in the Allahabad High Court, and unfortunately, or we can say it was a very bizarre, I don't want to criticize the court here, but the judgment was very different, which was not expected from the Allahabad High Court. What they did, they gave the 2-month cooling period. 2-month cooling period. Whenever such case would be, once the FIR would be filed against the husband, then they gave this 2-month cooling period. In this 2-month cooling period, the police would be restricted to take any action against the person. They cannot arrest him, they cannot seize his property and all that. They will try, it is because that there would be communication between the two parties. Maybe there are false allegations against the husband, so on this behalf they gave this 2 months cooling period in which there would be no action taken against the person or against the husband. Why it is given? The reason maybe they can conceal, or maybe there are false allegations. And why it is why there are false allegations against the husband? Because the Supreme Court also discussed about it, that whenever such cases are filed in the Supreme Court, in the courts, the conviction rate of such cases is only 18%. The conviction rate is only 18%. So it means that most of the cases, they are in most of the cases there is harassment from the woman's side against their husbands. They are blackmailing their husbands, or whatever the reason would be. So because of the conviction rate is very low, so the court, Allahabad court, gave this 2-month time period, and eventually it was upheld by the Supreme Court. So what does this article do now? It in a way criticizes this judgment. First of all, the article highlights that, even though, let's suppose there is only 18% conviction rate, but that does not mean that this low conviction rate, it is because that these men who are doing this domestic abuse against women, they are not guilty. But there are lacunae in our executive wing. There are lacunae that the police, there is corruption in our police system, in our executive system. So because of these lacunae, because of these drawbacks, there is less conviction rate in this, not because these people, they are not convicted. So it is something structural issue. The author here highlights that it is the structural issue, which is structural and functional issue, which is because of that there are low conviction rate. It is not because these people who are alleged that they had done any domestic violence, they are not guilty. So the situation is totally different. And here the author highlights that this judgment of the Supreme Court, how it upheld this cooling period, it in a way is going to derail, it in a way is going to impact the gender justice, it is in a way going to impact the woman, because they would be the ones who will get suffered by this, because they are the ones who are getting suffered because of this. They are the ones who are being violated under these domestic, under dowry acts, or under dowry, or various other social pressures. So this author, she highlights that these are the issues, these are the points which were important to be discussed, and she highlighted that for the judgment. She highlighted that this judgment of the Supreme Court, it in a way has diluted the woman, the gender justice. It in a way has given, unintentionally gave this the blind eye, this blind spot to these people, that it gave them the room, it gave the protection to these people, that they can further do this injustice towards the woman. So this is the crux of this article. Now let's have a look at the key points which are necessary for you to understand, because while reading these key points you will get the proper idea of this article. Let us see. First, mandatory cool off period. As we discussed, the Supreme Court has endorsed a directive that mandates a 2-month cool off period before any arrest or force action can be taken in case filed under the section 498A of the IPC, which deals with the domestic violence of the woman from the husbands or the relatives. Then impact on the victim. The article argues that this judgment puts victims of domestic cruelty at greater risk, as it delays police investigation that we had discussed and action. Even in cases with strong evidence, it is also seen as a move that could discourage women from filing complaints in the first place. That is also true. Once this room would be given to them, it will definitely discourage women in filing the complaints, because these men, they will say that, it will show that even though we can do anything to you and you can't do, even police will not come for your rescue, and they are given this time period, and men, they can manipulate these women. So there are various issues through which there are various lenses through which we can see this judgment. Then the third, debate on misuse of the law. The article challenges the popular narrative of widespread misuse of the section 498A. It argues that a low conviction rate, around 18% in 2022, does not equate to misuse, but rather points the systematic issues like poor investigation, a high burden of proof, and social pressure on the victim. So that's what we also discussed in our previous slide. Then third, it is also said that it is one of the prime example of judicial overreach. The author suggested that the judiciary has overstepped its bounds by acting on the premise of misuse without concrete evidence, and by suspending a law that was enacted by the parliament after detailed deliberation. So this is what we had discussed in this article. With this discussion, you need not to go back and read the article, that I can promise. Now let's have a look at what type of question can be asked, or what type of question can be relevant from this article. Here the question says, with reference to the criminal laws in India, consider the following statements. First statement, section 498A of the Indian Penal Code penalizes cruelty against women by their husbands or his relatives. 100% correct. Second, the new Bharatiya Nyaya Sanhita 2023 has completely repealed the provisions of section 498A of the IPC. They had repealed it. It has completely repealed the provisions of section 498A of the IPC. That is true. Then the third statement, The Supreme Court recent judgment has directed the police to automatically arrest an accused when a complaint is filed under section 498. Let's again repeat this statement. The Supreme Court's recent judgment has directed the police to automatically arrest an accused. No, it is incorrect because they had given the 2 months cooling period. So with respect to this question, the correct statements are statement 1 and statement 2 only, and this is the new Bharatiya Nyaya Sanhita 2023 has completely repeated the provisions of section 498A of the IPC in section 85 of the BNS. So this is true too. So with respect to this question, the correct statements are statement 1 and statement 2. Now let's move to the another article and let's have a little discussion over it. Well, this article is about the landmark study which offers new insight into what protects against dengue. Well, the issue with dengue is that, I will first give you the basic idea about it, then we will see the key points, and then we will understand what this article is about. Well, about dengue, you would have heard that there is no proper vaccine for it. The reason for that is because why there is no proper vaccine. The vaccine I am talking about, that vaccine on the first instance. Why there is no proper vaccine? Because dengue is such a disease. If it is infected in an individual for the first time, and it raises the concern, it raises the chances that that person may get infected again and again by the dengue with different with different strands, with the different with different types of the dengue, and it does not, in a way, the vaccine will not help in this regard. So this has been the understanding with respect to the dengue. So let me repeat the point. If, for example, if any person gets infected by the dengue, it does not mean that he will automatically start developing the immunity against dengue, but it is reverse of it. Then there are, what the reality is, there are more chances that he will get more affected by the dengue in the further coming cases. So with respect to this, definitely the dengue is a major global challenge, and it is caused by 4 serotypes. This dengue, it is caused by 4 serotypes, DN1, 2, 3 and 4. It is caused by 4 serotypes. So with respect to this, we understood that there is no proper vaccine. So in the recent study, what they had understood that they had developed a very unique way of treating the dengue. They had developed a unique vaccine for the treating the dengue, and this way, this new research, which it deals with the EDE like antibodies. It deals with EDE. It deals with EDE like antibodies. So what are these EDE like antibodies? It is envelope dimer epitope. EDE stands for envelope dimer epitope. So under this envelope dimer epitope, what will happen? Under this, what will happen? This type of vaccine, it would be given to those patients who had suffered already the dengue, and it will increase, it will act as a vaccine for them, and it will further help them boost their immune system and protect them from the further infections of the dengue. So this whole discussion revolves around this envelope dimer epitope. This whole discussion revolves around it. It is the new research which will help in the second or third case scenarios. For example, if a person is infected by the dengue second or 2 or 3 times, then such vaccine is for those people, and it will boost their immune system and will help them fight against dengue. But still, at the first instance, there is no effective vaccine so far. So this is the whole story with respect to it, and it is the research. So with respect to this, let's try to find out key points which could be relevant for your prelims exam, and also what were the key points in the article, so that you don't need to read the article again. So first, a key point, the article highlighted the understanding the dengue immunity. A novel study has identified EDE-like antibodies as the key component for building broad cross serotype immunity against the dengue virus. which has 4 distinct serotypes that we had discussed in ED, like which is envelope dimer epitome. ED like antibodies as they come as the key component for building broad cross serotype immunity against the dengue virus, which has 4 distinct serotypes. So with respect this with respect to the disease of dengue, there is a paradox of immunity. What is this paradox of immunity? Let's have a look at it. A major challenge in dengue vaccine development is the phenomenon of the antibody dependent enhancement. This is the major challenge with respect to the development of vaccine, which is antibody dependent enhancement. What is this? Where initial immunity from a first infection or vaccine does ironically increase the risk of severe diseases. Where initial immunity from a first infection or vaccine dose can ironically increase the risk of severe disease during a second infection with a different serotype. That we had discussed, that it is this under the antibody dependent enhancement or the paradox of immunity. What usually happens that in most of the diseases, if you are given the vaccine or if you get infected, in the future you develop this automatic immunity against such disease. But with respect to dengue, it is totally reverse of it. Now the research is being done on the ED like antibodies. Now let's see what would be the role of ED like antibodies, as it is the cross serotype, as we also discussed that there are 4 serotypes. Under this role of ED like antibodies, the study found that ED like antibodies are highly prevalent in 4 serotypes, highly prevalent in individuals with a strong secondary immunity, and are strongly correlated with the broad protection against all 4 types and reduced risk of severe dengue disease. That we had discussed that for those people it is mostly effective for those people who had already been infected by the dengue. Then implications for vaccines. The findings suggest that the future dengue vaccines could be specifically designed to elicit a high level of ED like antibodies to provide broad protection and overcome the challenge of ADE, which is antibody dependent enhancement. So this is the study which has been done in the Philippines with respect to the ED like antibodies, how it can be helpful for how it can act as a vaccine, and how further studies would be done with respect to the formation of vaccine for the dengue in this regard, because it is the cross link of the different, it would be the cross of different serotypes under dengue, and it can further reduce the impact of the dengue in the patients which had already been infected earlier. So this is the whole story about this article. I hope you, a little complicated, a little technical, but this is what you need to know. So with respect to this, let's see what kind of question can be asked in the exam. Here the question is very much simple. The question says, with reference to dengue fever and vaccine development, consider the following statements. First, dengue is caused by a virus with 4 distinct serotypes that we had discussed. Second, antibody-dependent enhancement is a phenomenon where prior exposure to the virus can increase the risk of severe disease upon a second infection, that we had discussed. Then the third, the newly identified ED-like antibodies are primarily responsible for increasing the risk of severe dengue cases. This is totally incorrect because it is the reverse of it. So with respect to this question, the correct statements are statement 1 and statement 2 only. And from the code below, the correct code would be option A. With this, let's move to the another article. But before we'll move to the another article, I would like to give the brief introduction about this initiative, which we had started from 2nd June. You know, under the name Target IAS 2026. Under this initiative, we had promised you that every day we are going to upload 2 videos. One in the morning session, where we will discuss the current affairs, which is this video. One in the evening session, where we will discuss the static syllabus. So with respect to the current affairs, we discuss the most important articles in the newspaper and break them down and try to relate you these articles, how they are relevant with respect to your exams and how the questions can be asked. And with respect to static syllabus, we had here promised you that by the month of January 2026, we are going to complete your full syllabus. Whatever is required for you to clear the exam, we will cover it, whether it would be related to prelims or mains, everything would be covered. And here already we had started with Indian polity, which we had covered. Then we discussed the governance part. And yesterday we were supposed to start discussion over the ancient history, but unfortunately, due to some work, I could not deliver my first lecture. But today, definitely, I am going to deliver my first lecture. And if you want to watch these videos, I have already the recorded ones are there, and from today we are going to discuss ancient history, and the video would be uploaded exactly at 6 p.m. So please do watch it. And at the same time, as we are delivering these lectures, at the same time we are preparing your notes. You know, these notes are very much different, because after every topic which we discuss there, we bring up the possible prelims as well as mains question, if the topic is relevant with your mains, so that it will give the idea how important these articles are, how important these topics are, and how the question can be asked from this topic. If you want to get, now cutting it short, if you want to get access to our notes, you just have to mail us. The mail ID would be given in the bio, and you would be told to pay 200 rupees per subject. Right now, the Indian Polity and Governance book, I would say again, it is a book, not notes like the other institutes. The book is ready. Ideally, its cost should have been more than 800, but as I had promised you that it would be only 200, but it is in soft copy. If you want to get access to it, please do mail us, and we will send you this book, because a very beautiful book. Every topic there, questions there, it will act as a test series for you too, because there are more than I guess 300 to 500 questions are there. I believe so. So very good for you. If you want to get access to it, please do mail us, and I would recommend you guys to do it. So this is about the initiative. If you want to be the part of it, please do subscribe the channel, do share it with your friends so that they may also get benefited from this initiative, and please do write in the comments what else should we bring for you guys. Now let's move to the another article and see what we had brought here. Well, this article is about the Delhi stray dogs to be captured and never released, the order from the Supreme Court. Well, what is the issue here? You know, if you would have stayed in Delhi, one of the biggest problem in Delhi is of the stray dogs. And unfortunately, the connection people have with these stray dogs is sometimes irritating. You know, I had seen people, it is good to love animals, and everybody should love animals, but not at the cost of humans. You know, you would have seen a video where a animal was trying to bite that person, but somebody around him, when he retaliated to that dog, somebody around him, he started to fight, he started to quarrel against that person. Why you are retaliating against him? Why are you retaliating against the dog? So this understanding the value of the humanity in some way has reduced in our country, unfortunately. The love for the dogs, it is good, but not at the cost of the human life. So with respect to this, the Supreme Court gave us very good, directive, very good, highly appreciated directive with respect to these stray dogs, and it in a way amended the Animal Birth Control Dogs Rule 2001. Animal Birth Control Dogs Rule 2001. So what did the Supreme Court said? The Supreme Court has issued a significant directive to the Delhi government and local bodies here to address the growing issues of stray dogs in the National Capital Territory. As we know that the stray dogs, they are growing at very high speed, and in Delhi, if you are living there, you cannot even retaliate to those dogs. The people get highly offended. I don't know why. It is good to have dogs, it is good to feed them, but not at the cost of human life. You know, they are going, if they will bite you, you will have to go to the hospital. You may get infected by the rabies. And unfortunately, it is not the adults who are the victims of that. Mostly it is the children who get victim of these stray dogs. So the Supreme Court has given the directive to the Delhi government and local bodies to address the growing issue. And the Supreme Court's court ordered authorities to immediately capture all stray dogs, sterilize and immunize them, and house them in purpose-built ponds. What did the Supreme Court said? What directive it gave? That it gave the directive, it ordered the authorities who are responsible for that to immediately capture these dogs, then sterilize these dogs, then immunize these dogs, then keep them in the purpose-built ponds. And don't release them. And then the court has banned the release of these dogs back into the public space and warned that any individual or organization obstructing the purpose will face contempt of court charges. The Supreme Court has been very much clear in this. If any organization, maybe there would be animal welfare organization or any for dogs, or there are localites who are very highly involved with these dogs, if they will try to obstruct this process, they will face the contempt of court. The court is very much direct here. And also the reason for this, the court's primary concern is public safety, particularly for children, and it has stated that no sentiment should interfere with this directive. The court has been very much straightforward with respect to this, that there should be no sentiments of the people towards dogs, that they should try to interfere with this directive. And it is very highly appreciated, much needed directive from the court, because the stray dogs is one of the biggest issue in Delhi. And also with respect to the now with respect to the animals, with respect to these dogs, the court is very much clear that there should be the infrastructure and accountability. The court made it very much clear that there should be the infrastructure for them and they should be very much accountable. The directive mandated that the establishment of shelters capable of housing 5,000 dogs within 2 months should be there. The shelters must be under CCTV surveillance, and authorities must maintain detailed records to the and to be submitted to the courts. What does the Supreme Court here say? That there should be the establishments for these dogs. The establishments or the shelters, it should be capable of housing 5,000 dogs, and these shelters must be under the CCTV surveillance, and the authorities must maintain the details record them with respect to the courts, and record them with the courts. So this is what the article has highlighted. Now let's have a look at the key points which are relevant for your preparation, which is important for you, so that you don't need to go back to the article and read it. Here the first important thing, immediate and unconditional action. The Supreme Court directed that the immediate capture of stray dogs from localities, emphasizing that there is no compromise on freeing public spaces from this menace. Then permanent confinement, capture stray dogs after being sterilized and immunized must be housed in shelters and are never to be released back onto the streets. Then public safety over animal welfare, that's what we discussed. The court sided with public safety concerns nothing. The increasing instances of dog attacks on children. It dismissed arguments from animal rights activists questioning if they could return children lost to rabid canines to their parents. Then the fourth, contempt of court. The court issued a strict warning that anyone who obstructs the authorities from carrying out this directive will be held in contempt of court, a serious legal charge which we had discussed in Indian polity. Then we have infrastructure and accountability, we discussed that. Then emergency response, authorities are instructed to set up a helpline to report dog attacks with a mandate to capture the dog within 4 hours of a complaint. So this is what this article is all about. Now let's move to the another article and let's have a look at it, what it is about. Well, again this time it is with respect to the pigeon feeding. Pigeons, with respect to pigeons, let's see what does this article here discuss about. The Supreme Court of India refused, here the article is about the Supreme Court of India refused to hear the special petition challenging a Bombay High Court order that directed the BMC there to file criminal cases against people feeding pigeons. Here the Bombay High Court, they had directed the BMC in the Bombay that to file or to file criminal cases against people who are feeding the pigeons, Why pigeons? Because with respect to pigeons, they are very beautiful birds, but unfortunately the beat of pigeons and the fur of pigeons is responsible for various respiratory diseases. So with respect to this, the Bombay High Court, they gave this directive that if anybody is feeding the pigeons in places in places where these pigeons accumulate together and they are feeding them, Kabutar Khana, in places like Kabutar Khana, then what will happen? Those people will be charged with the criminal cases. So with respect to this, there had been huge, the people had retaliated against it, especially from the Jain community. Because according to the Jains, it is one of the religious tenets to feed the pigeons, and one of the leader of the Jain community has stated that if this ban would not be revoked, he will go on the hunger strike. And there are various worse, statements made by these people. So with respect to this, the case went, they tried to file a complaint in the Supreme Court, but Supreme Court rejected this special leave petition under Article 136. Under Article 136, special leave petition. With respect to special leave petition, why they were forced to go for the special leave petition? This is the first thing which how you should analyze this article. Well, about feeding pigeons, it is important that what this story is about. What did the Bombay High Court said? That is good. That we understood. That Bombay High Court gave this judgment that if anybody is feeding, you should charge him for the criminal case. But the question which you should ask me, sir, irrespective of going for the special leave petition, why did not they just appeal with the Supreme Court, which they could have done? Why they did not choose this path and they went for the special leave petition? If you would have, when we discussed the Indian polity and when we discussed the judiciary part, in the judiciary part we discussed the various jurisdictions of the Supreme Court, the appellate jurisdiction, while it will hear the appeals. So while hearing the appeals, we discussed that to hear the appeal, the high courts, the respective high courts should give it in written. Why, should give the authority to the Supreme Court that you can hear the appeal, there is need to hear it. So first of all, there was no written complaint, no written authority, and we also discussed if the Supreme Court, if the High Courts rejected to give these written complaints, if, for example, now if the case is, we also discussed there was the exception that if the High Court has given any punishment which leads to death penalty or the life imprisonment, then Supreme Court will have to accept that appeal. If the cases are very normal like these, then this High Courts, respective High Courts will give it in the written. But here there has been no such written application from the High Courts. And also at the same time, now what was the option available to these petitioners, how they could have approached the Supreme Court. And then we discussed that there is something called a special leave petition under Article 136, which gives the jurisdiction. It is under the discretion of the Supreme Court whether to accept it or not. And the Supreme Court, it has rejected this plea. Why it has rejected this plea? Reasons are definitely, first, it does not Supreme Court does not felt important to discuss this matter there. And second thing, as the Supreme Court has highlighted that this matter is still pending in the court, let the court decide first. Once the final decision would be given, then they are going to take up the case and do the review of it. So this is what this whole article is about. It is about pigeon feeding. It is about the Bombay High Court's judgment that once you will find any person feeding pigeons, they will be charged under the criminal case. It is against the religious essential features of religion, whether it is the essential feature of the religion. The concept or the essential feature of religion comes in here that the Supreme Court has highlighted. For example, if any fundamental right is restored, is restricted, but with respect to the religious right, then which will stand? Will the religious law stand or the fundamental rights stand? That we had understood in Indian polity when we discussed the articles 24 to 29, that it would 28, it would be the judiciary will decide what would be the essential feature of the religion. So this will the discussion also revolves whether feeding the pigeons is the essential feature of the Jain's religion of Jainism. So there are various issues in which we can discuss it. But the story is the Jain, he warns of the strike, hunger strike. The Jain leader, he warns of the hunger strike. The Bombay High Court has banned it. There are health reasons why it has been banned, and the Supreme Court has rejected this special leave petition. Now the question can be asked with respect to this special leave petition, and let's first have a look at the key points in it. Then let's see that. First, what are the key points? The Supreme Court's stance. The Supreme Court dismissed a special leave petition, refusing to intervene in the case, stating that it did not want to conduct a parallel hearing while the matter was still under consideration by the Bombay High Court, that we discussed. Bombay High Court rationale: the High Court directive to file criminal cases was based on its concern for public health, declaring that feeding pigeon was a grave and potential health hazard and that humans' health must take precedence. Third, religious and cultural conflict. The court's order has led to a conflict with the Jain community, whose members consider feeding birds an important religious practice. Then protests and threats following the High Court order and the Supreme Court's refusal to intervene. Protests revoked tarpaulin covers from a pigeon feeding spot, and a Jain monk warned of an indefinite hunger strike and made controversial comments about taking up arms against the court. So, the court order. So, this is something absurd what he has said. So, with respect to this, let us see what type of question can be asked. Here, the question says, with reference to the Indian judiciary, a special petition can be filed under which of the following articles? Article 136. So, with this, let's move to the another article and see what is given here. This would be the last article of our today's discussion. Well, this article is about the recent repatriation of the Piparahwa relics. Well, what is this about? Recent return of Piparahwa relics. Well, these relics are believed, they were excavated in 1898. These relics were excavated in 1898, and they are believed that they are the relics of Lord Buddha and his first few followers. So with respect to this, there has been an issue. These relics resurfaced again for auction at Sotheby's in Hong Kong, promoting a swift and coordinated, which there was an auction in the Hong Kong with respect to this for the commercial use of it, or they were about to sell it in an auction. But the Indian government intervened at the time. They intervened at the best time. Because of the diplomatic efforts and also the public-private partnership, it was the Godrej industries groups, they participated in it, and they actually at the end they were able to get these relics, and they brought them back to India and hand over it to state. So the issue is not the story here. With respect to your exam, the question can come with respect to these Piparahwa relics, where they were executed and when they were executed. A question about it can be asked in the exam. But the broader picture is here that why it was allowed to be sold in the international market. The reason for that is there are no such laws which protects it. Even if there are laws, but they are not that stringent, they are not that strong. So with respect to this, India, we don't have such laws which could have protected it, and also at the international level. So because of that, this incident happened. So the article highlights that it is prime time for India to bring in such laws. In this case, we acted, but we acted as a reactionary. Our actions were much more, they were more reactions. And the author here highlights that we cannot react every time. We need to be very much proactive. We should bring in the laws in which we can protect these relics, we can protect these historical and cultural important things. So this is what this article is here highlighting. Now with this, let's have a look at key points in it. Here the first thing what it has highlighted the successful cultural diplomacy. India's coordinated diplomatic efforts involving multiple ministries were successful in halting the auction and repatriating the Piparahwa relics, which were discovered in a stupa in Uttar Pradesh in 1898. Then there was the public-private partnership. The repatriation was facilitated through an innovative collaboration between the government and the Godrej Industries Group. This private entity acquired the relics through a negotiated deal, setting a precedent for future recoveries. Then there is structural deficiencies. The article points out weakness in India's system for managing cultural heritage. The government's response was reactive, intervening only after the auction was announced. The legal status of the relics was complex due to their colonial era excavation. The need for proactive measures to address these gaps. The article suggests the need for a centralized, digitalized registry of cultural assets. There should be a centralized and digital registry of cultural assets integrated with the international auction house for real-time monitoring. It also calls for India to lead international efforts to create binding legal norms to prevent the commercialization of sacred relics. So this is what this article is about. I hope you had understood it. Very simple but straightforward. Now what kind of question can be asked with respect to this article? Let's have a look at it. Here the question is very straightforward. It says, with reference to the Piprova relics, consider the following statements. First, the relics were excavated from a stupa in Piprava, Uttar Pradesh. Correct. The repatriation of the relics was a result of public-private partnership. That is true. Then the third, the Supreme Court of India was instrumental in halting the intervention. No, it was not the Supreme Court. It was the diplomatically it was done by the government. So with respect to this question, the correct statements are statement 1 and statement 2. With this, we had completed our today's discussion. I hope you would have liked the video. I hope you would share it with your friends, and I definitely hope you would subscribe the channel. Thank you for staying with me. Thank you very much and have a nice day.